Assimakis Komninos, very warm welcome to Digital Markets Research Hub. As always, it's a great pleasure and honor to have an opportunity to discuss the latest development with you. And you were doing this summary of annual development in EU competition law for quite a while in different venues, and you established, this kind of expectation among competition law community or cluster of people to get the summary. So now we have a chance to have it in a audiovisual format. And in one of your latest or recent LinkedIn posts, you said that 2022 is a monumental year. So I wanted to start maybe by asking how monumental 2023 was in your view.
I think it was definitely a very interesting year as well. Perhaps not as monumental as 2022, because in 2022 we had a lot of one or two extremely important cases and judgments. So, for example, we had the Google Android, we had Qualcomm, we had the Servizio Elettrico Nazionale judgment of the Court of Justice. But I think the 2023 was also quite interesting, also in Article 102, definitely. And we see in 2023, we see, let's say, how each case is building on the other case. There's a dialogue always between a previous case, a new case. Maybe there was an error or a whatever, a thought that was not perhaps the best inserted in the reasoning in one judgment, then it gets corrected in the next judgment, and then it goes on and on and on. It's a developmental story. I mean, that's what the case law is about. It's very interesting to look at specific paragraphs that get always repeated, or they are reinforced. For example, paragraphs that are dropped, for example, when you see the new judgments coming on top of the previous judgments. So I'll talk about that in a second, but definitely very interesting year, a number of important developments, I think that both years, 2022 and 2023, were, let's say, fundamental years when it comes to competition law developments, both before the Commission and, more importantly, before the EU courts.
And I think it would make sense if opportunity allows us to refer to some of the 2022 cases, particularly if there is further development in the latest 2023 cases. But we cannot resist the temptation to unwrap the Christmas present given to us by the Court of Justice of the European Union in the 21st December, delivering quite a few significant judgment, and the cherry, or at least because everybody knows that they are experts in digital and in football, Superleague judgment is the one which attracted a lot of attention from purely substantive point of view, but it's equally important, if not even more important, from competition law sensu stricto.
Yes, exactly, and I will mostly concentrate on yesterday's Superleague judgment, a Grand Chamber judgment. Of course, the ISU judgment, again, is very important, but mostly the Superleague judgment. I think that this particular judgment is very interesting because it shows that the Court of Justice does not quite like, I would say, the when non-state actors essentially have too much of regulatory power in their hands. And by non-state actor, we are talking about actors. We're talking about essentially organizations, collective organizations, which are partly regulatory in nature, of course, not in the form of the state, right? It's more self-regulation. Partly they are commercial in their kind of nature, right? So, and this doesn't come out of the blue. If you see in the Four Freedoms, for example, there's a lot of case law about the quasi-regulatory power of these types of organizations. I mean, I can mention to you, for example, the free movement of goods, for example, where we do not have horizontal direct effect. The exception, however, is when you have these types of organizations which are acting quasi like a state, essentially. So I think the court drew inspiration from this type of case law and said that, listen, I have in front of me private organizations. These are not states, right? However, the effect of their actions is very much like state measures, essentially. And that's why you have a very prominent role of Article 106. We have an extension of the Article 106 case law, which is about state measures and state undertakings and undertakings which have special and exclusive rights. So I definitely see this as an extension of the 106 case law. Where this extension will stop, whether it will cover only these types of organizations, as is my view, or whether it can grow, let's say, broader, that is something that we will see in the future. To be fair, Article 102 has been influenced in the past by Article 106 case law. For example, the famous equality of opportunity type of case law, I mean, which in a way, in a sneakily, I would say, was there was a spillover from Article 106 case law into Article 102 case law. But now it's even more radical, I would have to say, and very explicit. Very explicit. The court is not, because it's very clear. It refers to Article 106, right? It refers to Article 106 in the judgment. So I read this as a kind of extension of the Article 106 case law. Clearly, the court was very influenced by the fact that these organizations act as a state within the state, one might say. Now, from the point of view of Article 102, from the point of view of of our kind of more specialized world, let's say, the judgment is extremely interesting. It builds on a few recent cases, in particular Servizio Elettrico Nazionale and also Unilever Italia. It builds on these cases. There is a particular point which I liked when I saw that paragraph 129 of the judgment in Superleague, where the court corrects an error. I think that was probably by error. I mean, it was not, I think, an intended unintended point in Unilever. It was probably an error, and it is corrected here. And the error is in what is an abuse. In Unilever Italia, the court says we have an abuse of a dominant position if you have conduct which goes against competition on the merits, and then there is an or it produces anti-competitive effects for less efficient competitors and so on. And then it cited Servizio Elettrico Nazionale for that proposition. But if you go to Servizio Elettrico Nazionale, it says exactly the opposite. There's an and between the two conditions. So we were kind of I was 100% sure that this was an error because it didn't make sense. I mean, if the court were saying such a huge thing, then what it was saying later in Unilever Italia would not make sense, right? And indeed, now I think the court realized that, and it corrects that particular point. And if you read paragraph 129, it's clear that this is cumulative, that you must have conduct which was against competition on the merits, and that conduct must produce anti-competitive effects, likely or actual. I mean, there nothing changes when it comes to insufficient competitors. So you need conduct against competition on the merits plus effects. This is the test, essentially, of what is an abuse, and that's very important. Finally, and I like that, I mean, there's a lot of references in this judgment about the basic as efficient competitor principle. So at a time that this has been severely under attack, I would say currently we have also the process for the revisiting of the guidelines. I don't think the Commission is particularly fond of that principle, but I mean, you see it very explicitly repeated in this Grand Chamber judgment.
Can I just, for clarification purposes, could you please explain if you could say that this mistake in obiter dictum, or instead of and infringement of competition on the merits and as efficient competitor, did you encounter people who would take it and try to somehow interpret it as a line of reasoning, and what implications, what is at stake here?
I don't think that this would I haven't seen it at the EU level, but I have seen it at national level, for example, where I don't want now to go into details, but there have been explicit references to that, saying, the court now makes it clear that you don't need effects, essentially. But if you don't need effects, then the rest of Unilever Italia makes no sense, because it's about effects. Then if it's either conduct against competition on the merits or effects, then you don't need effects, right? So all the case law, Intel, etc., would make no sense, essentially, to have, right? So it was clearly an error, I think. But still, there were people that were saying, the case law is changing now, But now, I mean, that makes it very clear that this is not the case.
Interestingly, you noted in about 106 that there is kind of change. The court is getting more vigilant and more nervous, maybe, about this growing power of quasi public entities, which such paramount power in terms of real economic and socio-economic relationship. And even other two cases, they indicate this 5 and 6 rules of homegrown players. It was considered as a kind of happy medium between the previous pre-Bosman stage and the significant reforms of the later case law, and now it's being challenged as well. So it looks that the pendulum is shifting towards a much more proactive and much more kind of critical approach of the Court of Justice. Yes,
however, because I have also seen in the first reactions some views that saying, this means that these kind of findings can now be used against normal dominant companies or super dominant companies or whatever. I don't think the court is saying that any dominant company that can control access to the market, that's it, we have a new type of case. I don't think the court is doing that, right? Because at the end of the day, you might say that especially if you have a dominant position which is quite sustained and an important dominant position, you could say that there's always a degree of control in terms of access to the market, right? But I don't think the court is saying that. The court is clearly speaking about quasi-state actors. And these are essentially these type of organizations which are very much like a state, like an international organization, as if they had sovereign immunity. They have their own judicial system. It's a totally different system of organization, and I think that's what the court is alluding to, even explicitly. So I would say.
Yeah, but okay, so you mentioned Unilever versus the Italian Competition Authority, and why wouldn't we start, and it's 2023, why wouldn't we start with summarizing this case?
Yes, exactly. I mean, so we started in 2023 with two very important Article 102 judgments. One was Lithuanian Railways. That is an important case because the issue there was, should you need to fulfill the Oscar Bronner criteria for refusal to supply when it came to the particular conduct at stake. The court didn't think so, and the court followed the Advocate General Rando's opinion there, which was a great opinion, by the way, and said that, no, I'm sorry, this is a totally different type of abuse. You have destroyed your own property, essentially. And in a way, the court applies a no economic sense test, and says, when you have a dominant company which destroys its own property, this has nothing to do about the refusal to supply. This is not, the test should not be applying here, because it's a clearly different type of category of case, let's say. Then we had Unilever Italia. That had two major issues. One was conduct of distributors that were controlled or whatever, closely controlled, or they fell part of a particular distribution system of the dominant company. Should their conduct be attributed to the dominant company? And the court said yes. The court, by the way, did not follow, on that particular point, did not follow Advocate General Rando's opinion. I think it did well not to follow Rando's on that particular point, because I think Rando's was seeing the conduct of the distributors and the conduct actually Rando's was seeing the distributors as being part of a sort of a single economic unit with the dominant company. And I don't think that would have really been appropriate to say in this particular case. Also, because then immediately what would happen with Article 101 if we had agreements between the dominant companies and its distributors? If it's a single economic unit, then there is no Article 101 agreement, etc. So that I think the court did very well. And then, of course, the other part is on the abuse. The court essentially again followed, and I would say even more explicitly mentioned, the procedural nature of the duty of a national competition authority to properly take into account as efficient competitor tests submitted by dominant companies and other types of analysis. Remember, this is about an exclusive dealing case. It's not a pricing abuse, right? It's an exclusive dealing. And what Unilever did there, they asked their economists to produce an efficient breach of contract type of theory. In other words, how much does it cost for a competitor to pay the customer to breach the contract with the dominant company? So because everything has, at the end of the day, a price tag, right? So it was a very interesting theory. And the Court of Justice said, well, obviously the competition authority is not bound to run such tests, but the competition authority has a duty to hear about this type of evidence. And actually, the Court of Justice goes a bit further there and says not only should the Commission or the National Competition Authority hear and possibly reject this evidence, but must also explain what other evidence it has that somehow trumps the particular economic evidence that the dominant company has submitted. So in other words, it's not enough to say, oh, your evidence has A, B, C, whatever errors, and therefore we're not going to look at it, but you have to put forward an alternative economic theory as to why your theory is better than the theory that, or the tests or whatever the evidence proposed by the dominant company. So that's a major, I think, development. Staying with Article 102, we had the Towercast judgment, obviously very important. Mergers and competition and Article 102. I have always believed, by the way, that Article 102 was applicable to mergers, because merger regulation could never really trump the direct effect of Article 102. It's a different issue if Regulation 1 2003 says that the Commission will not apply these rules, but when it comes to national courts, there is nothing really that can block the national courts from applying Article 102. So I was not surprised by this case. This case is very interesting also in the context of the Illumina Grail drama that at some point we will have a judgment there. We had the hearing, as you may have seen, a couple of weeks ago, maybe 2 weeks ago or 1 week ago, I can't remember, a couple of weeks ago before the Court of Justice. And Towercast was prominently mentioned there. Then Facebook, I mean, the German Facebook case, not much on competition law, but still, I mean, the proposition that the court stood for is that for sure national competition authorities can apply the GDPR, but in an incidental way. But you know, at the end of the day, they apply Article 102 and they take the GDPR as a kind of benchmark, let's say, in their own evaluation of Article 102.
DB station maybe in this context, like
DB station is very important. It's I think DB station will stay as a controversial case. Controversial because of the direct effect of Article 102, which in this particular way, in this particular case, however, the Court of Justice seems to kind of place to nuance a bit. Essentially, DB station is about the prominence, I would say, of public over private enforcement when it comes to this type of regulatory issues. So, for example, when there is a national regulator based on secondary EU law, like in this case, in reality, the Court of Justice is saying that we should have first a decision of the national regulator, and then the national courts can apply Article 102 to the case. Essentially, that's what it's a rule of precedence, let's say, of public over private enforcement. It makes sense. However, it is very controversial because precisely of the direct effect of Article 102. I was not 100% sure that the court would go there. The court probably struggled between the direct effect point, you know, the principle, and pre-existing case law on this particular issue, which was, however, not about the direct effect of Article 102, but it was very similar to the types of questions that the court had. So I guess there was a compromise solution there and in fact, the judgment is a bit cryptic. It's not one of the clearest judgments. Let's say.
I recollect in this context earlier this year a message by Justin Lindeboom, who said that all provisions of the treaty have, or which are there, clear enough and all meet all this criteria. You can somehow say that regulatory approach also has direct effect, that 102 is not exclusive in this regard.
I wouldn't. I mean, there's a principle of precedence, and there's a principle of precedence and higher, let's say, hierarchical value of the treaty vis-a-vis secondary EU law, because in this case we had Article 102 versus secondary EU law, a directive, if I remember well, which was about regulation in the rail sector, right? So there is a hierarchy, right? But at the end of the day, I think the court acted in a very practical way and said, listen, yes, of course there is direct effect, but you know, there are these regulators, and these regulators are specialized, and this is about technical issues at the end of the day. Isn't it better to wait to have first the regulator's decision, and then of course national courts can take it from there, and obviously they can apply the treaty provisions and so on. The court, in fact, if you read it, doesn't say that the national courts are blocked. They cannot do anything. It pretends that direct effect is there is no issue, but then there is a particular passage in the judgment which says, but still, claimants should first place their claim before the national regulator and wait to see what happens. And in any event, there will have to be coordination between the two instances and cooperation, etc. But in reality, practically speaking, that's what it is. It's a rule of a precedence of public over private enforcement.
And claimants obviously say, look, we're waiting for 10 years, even longer. How long is a piece of string? But that's, yeah. But there is another case where you have to basically, we have to congratulate you on Bulgarian energy holding. Can you summarize to us the key elements of this complex in terms of substance case?
There's a lot of, it's a very complicated case because of the facts. And if you read the judgment of the General Court, you see, I wouldn't say rare occasion, but you see one of those occasions where the court goes really into the substance of the case and goes through the findings of the commission one after the other. In that respect, this is what lawyers and practitioners expect to see from the General Court. Really, this type of control of the merits of the findings of the commission in this case. This is, I think, a unique case in the sense that in reality, the court, the General Court, thought that there were errors in the findings of abuse. There were some errors, procedural errors as well. But I mean, if you read the judgment, it's clear that the finding of abuse is really where the core is really the area where the decision was problematic. And of course, procedure is a plus, let's say. In that respect, this particular case is slightly different. It's the opposite of Qualcomm, for example, where really the main issue was procedure, due process, etc. And then there was a finding of a finding that the commission had made errors on the substance, but it was secondary. So this was, whereas this, it's clear that it's the finding of abuse that was at the core of the issue. And in that sense, it's the first case since in the 70s, right, that we have a full annulment, all the fine, a full annulment of a 102 decision, and a full annulment basically because of a finding of abuse I have never seen before. So perhaps it's a first in that sense. The issue was about whether the facts could be fitted into the test of refusal to supply. And the General Court, in my view, following Google Shopping in this case, said that if this is the refusal to supply, for a refusal to supply, we need to have an explicit request to be supplied and an explicit refusal. Here, there is nothing, we cannot fit the facts into that test because clearly there was never really conduct that you could say this amounts to an explicit refusal to supply in this case. I mean, there's a lot of facts there. One needs to read the decision thoroughly. There's interesting stuff also on counterfactual at some point where the court says that even with the existence of these restrictions, still there's no possibility that the competitor could have brought gas in because of other issues, essentially. And these issues were not due to the conduct of BEH in this particular case. So very, very important judgment. We'll see whether there is an appeal or not. What else do we have in terms of Article 102? I think
guidance, enforcement priority.
Of course. So yeah, and then currently we had in March of 2023, we had the amending communication of the Commission, where the Commission changed, tweaked a bit, minor tweaks, but still significant, the 2008-2009 guidance paper. And currently the Commission is preparing guidelines on Article 102. This is a major development, probably the biggest development in terms of policy in competition law in 2023. We will see what the Commission will come up with. I expect to have a weakening of certain principles like the sufficient competitor principle. Certainly, the Commission will make clear that the sufficient competitor test is not something that they should be doing. Or at least, of course, they will take a look at it. They can't do otherwise, right? In any event, because of the Court of Justice's rulings. So, but I think they will try to make clear that when it comes to these types of cases, we may wish to protect also less efficient competitors, and therefore going to the costs of the dominant company by itself may not be enough. I expect them also to kind of, in conflict with the case law, I have to say, but I expect them to try to make clear that exclusivity rebates, for exclusivity rebates, there is a presumption that they are unlawful, that they're restrictive, and that's it. Because they categorize, I mean, exclusivity rebates in a different way than other types of rebates. By the way, this categorization is wrong in my view. That's precisely the categorization of the General Court in Intel, which was annulled by the Court of Justice. I mean, after the Court of Justice Intel judgment of 2017, there are only two categories of rebates. One is the quantity-based rebates, which are presumptively lawful, and then all the rest, i.e. loyalty, exclusivity, all these types of rebates are subject to an all circumstances test, which the court has expounded on in paragraph 139, if I remember well, of the Intel judgment. We will see. It's an interesting area, this one.
Let me pause here. In one of your conversations with our, I wouldn't say sister, cousin podcasts with Pablo Trevistan, you addressed this in more detail, and in conjunction with Servizio Elettrico Nazionale case, saying that it's not like you cannot, the Commission today is in a different position than it was 20 plus years ago, when the more economic approach was such a topical issue, and they didn't have carte blanche, but they had much more flexibility with selecting and declaring and interpreting, maybe, and saying that in exclusionary abuses, that's what will be our polar star. Today, the situation, according to what you were discussing with Pablo Trevistan, is different. Can you elaborate on this, please?
Yes, obviously, because, when we were back in 2005, when the Commission started the process, we had a rather restrictive case law. We had all these cases, Michelin 2, we had British Airways, all these cases which were extremely formalistic, I mean, that's clear. And the Commission tried, I think the Commission did well to do that, tried to insert a more economic approach into these types of into exclusionary abuses, and tried to explain that form, whether you have a certain external characteristics in conduct, for example, means nothing at all. You should look really at what their effects are on competition, right? And the Commission also stressed that you may have conduct which excludes competitors, but this is not anti-competitive. If the conduct is pro-competitive, for example, you will have, of course, competitors who are excluded. That's the anti-competitive foreclosure principle that the guidance paper introduced. So all this, obviously, the Commission was not bound to do, because the case law was quite accommodating for formalism, essentially. However, the Commission limited its own, in a way, discretion, and said, I'm not going to prioritize, call it as you want, prioritize, or I'm not going to make investigations into types of cases which, for me, are not deserving, let's say. And what are the types of cases that are not deserving? The types of cases that are about essentially protecting competitors as such, or about formalism, etc., etc. I'm not going to act like that in the future. And of course, the case law being what it was, However, the Commission was free to do that. Then gradually, very initially, we saw that the Court of Justice was not so happy with that. I mean, I can remember some Advocate General opinions by Advocate General Cott, very damning against the guidance paper. But then gradually the guidance paper was embraced by the Court of Justice. And sometimes the Court of Justice even went further than the guidance paper, right? So now this is a state of affairs. We're talking about a quasi-criminal area, right? So these are the tests. This is the case law. The Commission cannot now say, I have different priorities now. No, I mean, it could not condemn a company, for example, in a way that would go against the case law of the Court of Justice. That would not be possible, right? So that's the different situation currently. And now, that being the case, still, of course, the Commission is quite influential. It may hope that, there will be certain tweaks, certain nuances in the new guidelines. It may hope that in the future, in the same way like the Court of Justice was influenced by the guidance paper, in the same way you may have some influence of these new guidelines for the future in the case law. That we cannot exclude. But definitely there's a very much different situation currently than in 2008, 2009. That's clear.
Let us move to 101. Obviously, you can find some important 101 cases if you're really keen, but you mentioned relatively recently that we see the dropout of 101 cases, and you started somehow hypothesizing maybe it's because compliance is more improved, or maybe the priorities are changed, or maybe it's compendium of factors, including the cascade of follow-on actions. Is the trend continuing this year?
So first of all, let's not talk about Article 101 generally, because we had some interesting cases in Article 101. We had the EDP case in the Court of Justice. We had the Superboc. There is an Advocate General's opinion in a banking case, preliminary reference from Portugal. So there's a lot of interesting developments there. I was talking about cartel cases. Cartels, indeed, there are not that many cartel cases. In the old days, Oles, just a little bit before Christmas, let's say the last 2 weeks before the 20th of December, you would have a cascade of decisions issued by the European Commission on cartels. So you would have tens of millions of fines and sometimes hundreds of millions of fines imposed, sometimes billions. So in cartel cases, and usually these decisions would come to an end just before Christmas. And we lawyers, we would always make jokes about the Commission making our Christmas miserable, let's say, because then you would have the 2 months and 10 days to appeal. Now, this year, this hasn't happened. There was a minor thing, recently, but nothing much. Why is that? And indeed, there's not a lot of cartel cases. Maybe, indeed, there is less, I think, the types of the types of hardcore kind of secret behavior, like the gross type of cartel behavior that we no longer have, I think. Yeah, of course, I'm sure there's still going on some cartels, but these cases have become more rare, in my view, because there's more competition culture, or because, the fining policy has borne fruit, and such type of conduct is avoided. What we have, I think, is information exchange cases, or cases which, from a theory of harm point of view, are very similar to cartel behavior, but they don't have the external characteristics of cartels. Some of these cases are extremely difficult to unearth. So, it's just a different, I think, way of behavior. I don't have a lot of evidence on that, but my sense is that things have changed. Then another thing is leniency. I'm told that now that leniency applications are going up again, but for a period they had really dropped quite a lot. One possibility is that the follow-on damages claims all over Europe, which have now been quite numerous in various member states, they may have had a toll on that. They may have taken a toll on leniency applications. One possibility would be to immunize entirely the immunity recipient from damages claims. I have previously supported that in some of my writings, but I'm told by people within the Commission that, yeah, okay, but we have seen also that the number 2 brings a lot of interesting information, and sometimes the immunity applications are not so good, and you need the number 2 and the number 3 and so on, and therefore if you were to immunize the immunity recipient, then we would suffer on number 2 applications, leniency applications, etc. So it's a complicated area. It's not so easy. It's not easy to find a solution.
Let's move to another complicated area. You mentioned recently, I'm quoting, proliferation of state subsidies with a view of creating EU or national champions, or to standing up to foreign champions. Let's not be naive logic. And maybe also in conjunction with this kind of reference, omnipresence of the words industrial policy, something which was kind of, if not taboo, then at least faux pas or kind of toxic references to something which blurs the clarity of competition law as we knew it 20 years ago. Is it a trend? Is it kind of mutation in your view, or an organic development? How do you see all this?
This is the biggest concern currently in competition law enforcement. It's the biggest challenge. All this public money that is easily given to companies, essentially, in order to create or to sustain national champions or even EU champions, etc. And of course, let's not be naive. Logic is that there's a basis in that, right? I mean, there are policymakers who are saying, come on, I mean, look at other countries, and you know, there's a lot of public money which is very generously given to their own kind of champions, and here in Europe we essentially self-limit ourselves through the state aid policy, right? This is the logic, essentially. This is the let's not be naive logic. Now, I mean, does this mean that we should abolish state aid control, essentially? And does it mean that we should just give in and you know, you have member states showering money here and there? The problem is the internal market always. I mean, if the money were coming from a common EU budget under common criteria, I might not have a problem with that, right? The problem here is, however, that there are different national budgets, and these types of policies essentially are bound to be national policies that are bound to distort the internal market. And I mean, okay, irrespective of the latest developments in Germany with the Constitutional Court essentially imposing limitations, etc., but still, I mean, there are some countries like Germany, extremely rich, you know, their budget is definitely different than the Greek budget, right? So, you know, I mean, this is the main issue here. Internal market will be completely fragmented if we allow this type of if we weaken our state aid control in these cases.
And foreign subsidies regulation, how do you see it?
Let's see if it works. I mean, I hear that there are few people there. I mean, there are far too few people in the Commission that are dealing with such cases. I know that they are very conscientious and they're doing a good job and they're asking questions. And of course, companies obviously try to do the best. they can to comply, but let's see, because we are really talking about very few people doing that in Brussels.
Okay, so let us. I understand the reasons for the argument that this kind of industrial policy or protectionism vulgaris cannot work, and there are many reasons. But let us not be naive. Logic is also present in the kind of more sophisticated, more kind of demiurgian or Machiavellian vision, let's say, to digital markets. You, among your other prominent roles, you've been also a public official. You were a commissioner in Greek in Hellenic Competition Authority. So I wanted to ask your view as a thinker. Assuming that the challenge is there, or maybe not challenge, let's say opportunities for Europe to scale up and to pave the way for the next generations in which everything will be digital, to make them more competitive, let's say. How would you draft the DMA? Would the DMA be a solution for this? Is it something more strategic, less related to competition sensu lato, more related to Central European Investment Bank or something like this?
The DMA probably was conceived by some of the co-legislators. Certainly, I think, to a great degree, the European Parliament, as a sort of tool of industrial policy. There's no doubt about that. I think there are some people there who see it as a tool of industrial policy in the digital area. I'm not saying that the Commission, which proposed the legislation, thought in that sense. But certainly some MEPs in particular are very vocal and they see it like that. I don't think, however, that we should see the DMA as a sort of industrial policy driven tool. The DMA is a quasi competition law statute, essentially. And the main purpose of the DMA is to protect business users. That's what it is in reality. The aim of the DMA is to protect those business users that build products around services that are controlled by gatekeepers. Fairness and contestability are the two main objectives, but in reality, if you scratch below these two terms, what you see, and in fact, if you go to the substantive obligations in 5, 6, and 7, in reality, the vast majority of these substantive obligations are about treatment of certain business users, right? So that's what it is. I mean, it's a statute, of course, which is a sort of competition law. I mean, clearly, all these obligations have had something to do with competition cases, investigations, judgment, decisions, etc. They're not really about the end user, I think, although the end users are mentioned here and there. There are a couple of obligations maybe that where, yes, the end user is a beneficiary, but in reality, it's about smaller companies, smaller than the gatekeepers. And the aim is to allow these companies to build their own kind of products and services, and possibly to increase innovation. But this is not really the type of innovation. I mean, it's a kind of follow-on innovation of secondary nature, I would say. It's not really the who would be the competitor to Google, to Amazon, to Apple, etc. That's not what the DMA is about. That's clear.
How would you do it?
Well, I mean, first of all, the DMA is a reality now, and we have to make sure that it's successful. There are some elements in the DMA that I don't particularly like. I don't like the inflexibility of some of the provisions. I would have followed a system which is closer to the German or the UK system. I would have had the Commission essentially. I would have given the Commission discretion to nuance the rules and to kind of shape the rules and the obligations according to the particular business model and according to the particular case at hand. I think it's a bit too inflexible in that respect. I would have not allowed standalone private enforcement because it can be quite disruptive. I would have allowed follow-on claims, obviously, once there's been a finding of non-compliance. But again, what I find a bit like a straitjacket is you have these obligations which are self-executing, obviously, okay, but then they may even, I would say, they may even block the Commission from thinking creatively sometimes. Then you have private enforcement, so the Commission will tell you, well, we can be with you on that particular matter, but what if somebody goes before the national courts and then the case goes to Luxembourg and blah, 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 blah. So you see, this is not ideal, I think. I think that the Germans got it probably better, I have to say, there. I mean, when it comes to the digital system. Of course, the Germans cannot enforce that system, and that's good that they cannot enforce that system on gatekeepers, because otherwise, why do we have the DMA? But as a kind of legislative model, I would say I would have gone for something a bit more flexible, let's say, a bit more flexible.
And this leads obviously to the issue of regulatory dialogue. And do you think this regulatory dialogue could be constructive if, obviously for this you need exclusivity, I imagine, and also you need the vision and maybe long-term idea, and it cannot be very volatile. So it's a really delicate and nuanced mechanism. But do you believe in regulatory dialogue, or it's kind of we will end up with kind of all this rhetorics of capture and maybe evidence of capture? And
yeah, I mean, first of all, this is regulation, this is not competition law, so that's if you don't have a regulatory dialogue in regulation, then why do we have this? We might as well go back to competition. The authority sees you as a kind of defendant from the very beginning. We go into quasi-criminal adversarial type of sub-proceedings, and then that's it, right? And then maybe at the end, maybe you go in a different direction, you offer commitments, and it becomes again less adversarial, but maybe not. I mean, most cases, that's not the way. I mean, you go for an infringement decision. So the whole idea behind the DMA was to adopt a ex-ante approach and to avoid these types of dramas later on, to legislate in an ex-ante approach. Now, I mean, that's regulation. That's the very nature of regulation. Of course, when it comes to regulation, of course, you need to have this regulatory dialogue. Of course, I mean, the gatekeepers are by definition the ones that know much better than anybody else their business models and their practices and difficulties in complying with the specific obligations and so on. And third parties too will be, no doubt, they will be heard by the Commission, and their views will be quite important in that sense. So you need to have these types of dialogues. That's clear. And currently, my understanding is that these types of dialogues exist and continue to exist. And we may even have a more formalized process in the form of specification decisions in the future for Article 6. But that's what the regulation is about.
Last question. In light of the first designation challenges, the question of core platform services has not been the most topical during these 2 years of discussion, or it was, but how should we include voice assistants, clouds, etc. So it was less about why do we need such categorization, but and UK probably is learning the lesson by saying that we don't need core platform services. We have digital activity, i.e. activity, which is done digitally. So it's kind of very, they have their own pitfalls. Of course, we have. My question is slightly, more complex in a sense. Do you think that by avoiding this, let's call it pitfall from the perspective of the enforcer, we would end up with the next one? Is there a kind of, if we increase competences, you will find quasi-criminal, procedural, counterbalance? Is it like, from let's say, how the system functions. I'm asking it in the context of UK discussions. Do we need judicial review standard or full merits review? And some people say it doesn't matter that much, regardless how narrow or wide the scope of judicial scrutiny will be. There will always be counterbalance because of the high stakes in this game, which will thematize the most innocent sleeping dog, to use Christian Jorge's vocabulary, and bring it to the judicial, topicality, so to say. You are probably one of those who are most skillful in terms of thematizing these issues. Is it inevitable? Is it kind of almost like law of gravitation?
If I understand your question correctly, I mean, let's make a distinction, first of all, between two types of decisions in the DMA. We have the designation decisions and the specification decisions. That's one group of decisions. Here, we're talking about a regulatory function in reality of the Commission. And then you have the non-compliance decisions, which are indeed about enforcement. There, the non-compliance decisions are indeed quasi-criminal. That's clear. They are quasi-criminal because it's about imposition of fines, etc. The other decisions, the earlier decisions, like designation decisions and specification decisions, are not quasi-criminal because this is not about fines. Now, should there be a different standard, let's say, of review when it comes to the first and the second decisions? First of all, when it comes to EU law, all these decisions are at the end of the day acts that the courts will review. The court will review the legality of those acts, but in reality, we know very well that the general court at least will perform a control which is close to a full merits control. At the end of the day, the Commission has to do a good job. It has to be persuasive. The Commission must have done a good job. Now, yes, of course, when it comes to non-compliance decisions, imposing fines, etc., the courts will probably be a bit more cautious, and they will be careful. I mean, you read the Intel Renvoi judgment, it's very clear. I mean, there the court says, this is quasi-criminal, in dubio pro reo, and so on. So there will be these nuances between the two decisions. But my view is that at the end of the day, it doesn't matter so much. What matters is that the public authority must have done a proper job. It must be persuasive. It must make sense, and therefore, if you have errors or if inconsistencies, etc., whether it's a designation decision or a specification decision or it's a non-compliance decision, it will not make much difference. I'm not an expert in UK procedures, but my sense is that anthropologically speaking, that the judges are not stupid. Sometimes they use the sniff test, they will just see how the case looks like. Now, whether the standard is this, the standard is that, okay, yes, I can see that. But, if the decision is poor, the decision will fail.
Thank you very much. It's not the first time where we have an opportunity to discuss competition and digital competition law. And as you know, we finished conversation with asking for recommendations, and you did provide recommendations for students. I wanted to ask you a narrower question. Recommendation for those who want to pursue their career in White Case. Are you searching for polymath? For people who with unique personality who can do everything, or you're searching for being part of the broader team and you have to be expert in something really narrow, but you have to be really world-leading authority or ambition to become a world-leading authority, or something in between?
Mm-hmm. That's a difficult question. That's the most difficult of the questions that you put me tonight. Well, I mean, what makes a young graduate a good, let's say, candidate for a firm like us? First of all, that particular person should have a good basic law degree and from a good university. a postgraduate degree in European law or indeed competition law, if it comes from the UK, the College of Europe, but also other reputable universities. And then a stint with the European Commission, a stage with the European Commission, or a national competition authority, or another firm, for example. All these are like the formal characteristics. But more importantly, what makes somebody a good candidate and hopefully a good lawyer in the future? It's the ability to think proactively, effectively, to be effective, to collaborate, because this is not about units, this is about teams, essentially. Very rarely there are cases that you can do with one or two lawyers. I mean, in most of these cases require a big team, and therefore you have to work closely with other people and so on. For me, the most important element is the ability to think quickly and to be able to grasp the nuances in particular cases. And also, and this is something that I always repeat, I don't want lawyers that take the microscope and look at the vicissitudes of a particular case, and they know everything about different paragraphs and different, this is not, I mean, it's good to have some charismas in that sense as well, and to remember things and all that. But I'm more interested in people that can take a step back and look everything in context. That is where the good lawyer essentially will take decisions on how to draft pleadings, how to plead a particular case, how to advise the client, because you need always to look at the broader picture. Otherwise, you get lost in the detail and you become a technician. That's not what we should be doing, right? That's very important. So always look at the broader picture and be able to synthesize and act effectively, and also time efficiently, because we are not writing PhDs here, which you can write in 7 or 8 years. We just want to produce a good pleading or a good memorandum or a good paper, essentially, for the client that explains things in an appropriate way.
Assimakis Komninos, thank you very much for this brilliant conversation. It was a pleasure to have you.
And thank you, Oles. I wish all happy holidays and happy New Year 2024.